Hi everyone, my name is LaToni Smith and I am a juror for the Ashford University case for Howard versus Simmons. First, please allow me to give my summary of the case. A public hospital, in response to a subpoena, which was not accompanied by a court order, impermissibly disclosed the protected health information, or PHI, of one of its patients. Contrary to the privacy rule protections for information sought for administrative or judicial proceedings, the hospital failed to determine that reasonable efforts had been made to ensure that the individual whose PHI was being sought received notice of the request and or failed to receive satisfactory assurance that the party seeking the information made reasonable efforts to secure a qualified protective order. After careful consideration and research, I have decided to go in favor of the plaintiff. The plaintiff is suing Ashford Hospital for the improper release of her health information protected under the privacy rule. The Federal Privacy Act of 1974 provides that no agency shall disclose any record which is contained in a system of records by any means of communication to any person or to another agency unless a written consent is obtained by the individual to whom the record pertains to. In this case, the plaintiff, who was a patient as well as an employer of the hospital, is suing the hospital because she felt as though she was a victim of a breach of confidentiality. Let me explain the definition of confidentiality in the healthcare setting. Confidentiality is one of the core duties of medical practice. It requires healthcare providers to keep a patient's personal health information private unless consent to release the information is provided by the patient. And in this case, the plaintiff's boss had access to her health information, in which it contains her birth date, social security number, payment information, medical history, and different things that she felt was breach of confidentiality. The Privacy Act of 1974 provides that the agency should not share her information if she did not give them authorization to do such. In this case, the agency shared her information, which through an operating schedule that they use via email to the employers of the hospital to let them know the operating schedule. Also, when the operation will be performed, and the patient's name and information. I felt as though her privacy was taken from her. Privacy in medical and healthcare setting terms is the right of an individual to keep oneself and oneself information concealed or hidden from the unauthorized access in view of others. Privacy also refers to the capacity to control when, how, and to what degree information about oneself is communicated to others. In this case, the plaintiff did not want her boss to have access to her personal information. I actually found the incident that's relevant to this one. The case of Britney Spears in 2008. Britney Spears was seen at UCLA's medical center. 13 employers were terminated for inappropriately accessing Britney Spears' medical records. Also, Kim Kardashian at Cedars-Sinai Medical Center, where 5 employers and a student research assistant were terminated for accessing Kim Kardashian's health records. This shows that this does not just apply to ordinary people like me and you. It could apply to doctors, celebrities, as you could see, and people can really get sued off of things like this. That's why I'm taking it so personal. And each person is different, I know. Some may think it was not as private. Some may not care that their information is being spreaded to others. It might not be as personal as it is to some people. But in my opinion, it was a breach of confidentiality, and it did not align with the Federal Privacy Act of 1974, where she had every right to protest that they gave access to several employees that were not on the team to perform the surgery. They had access to her personal information, which included her social security number, date of birth, age, medical records, and so forth. There's a lot that people can do with personal information such as that. You can steal one's identity. You could know what's going on in someone's personal life that they might not want anyone to know. That being said, I am in favor of the plaintiff. Thank you for listening. I hope to hear your comments.